Good day to you and welcome to another Paddocks Club video tutorial. Today I'm going to continue in the series of dealing with prescribed conduct rules and move on to that prescribed management rule 3 that deals with vehicles. It has 4 segments. The first one starts: no owner or occupier shall park or stand any vehicle upon the common property or permit or allow any vehicle to be parked or stood on the common property without the consent of the trustees in writing. Secondly, the trustees can cause a vehicle to be towed away or removed at the risk and expense of the owner if it is parked, standing or abandoned on the common property without their consent. Thirdly, owners and occupiers of sections must ensure that their vehicles and those of their visitors and guests don't drip oil or brake fluid on the common property or in any other way deface the common property. And finally, in 4, no owner or occupier is permitted to dismantle or effect major repairs to a vehicle on any portion of the common property, even in an exclusive use area or in a section. The first comment is that this rule can be altered by the developer on the opening of the sectional title register and thereafter by special resolution of the body corporate. It doesn't often happen. The prohibition in 1 does not apply to any part of the common property that is subject to exclusive use parking bay rights or parking rights or any visitors parking bays. So the permission that you need from the trustees clearly is in regard to unregulated portions of the common property. In his book Sectional Titles, Prof. van der Merwe confirms that the terms of this rule allow the trustees to remove or tow away vehicles even that don't belong to owners or occupiers but to other people. So visitors' vehicles abandoned on the common property, for example, also may be removed. The trustees should, however, bear in mind that in terms of town planning legislation, the scheme must have visitors' parking bays. It's not unusual for a scheme to be required to provide 1 open visitors parking bay for every 4 residential units in a scheme. While in practice these bays may in fact be used by residents, the trustees aren't entitled to give any resident permission to park in such a bay because that's, in terms of the town planning scheme, got to be kept open for visitors. If parts of the common property are clearly set aside for open parking, then the trustees will of course be considered to have given consent for the parking of vehicles in these areas. Owners may, in terms of Section 39(1) of the Act, give trustees directions as to how they should control parking on the common property insofar as there is open parking. If a scheme doesn't have sufficient off-street parking to serve the needs of its residents, and there are unallocated parking bays on the common property, the trustees should take and record in the minutes of their meeting a parking policy that sets out the rights and obligations of residents in their use of those bays. Notice of this resolution should be posted on a notice board on the common property or otherwise communicated to all residents. In some schemes, I have in fact seen quite complex amendments to this rule to cater for parking, charging and all sorts of things. There's no limit to what you can do in the regulation of parking on the common property. That's assuming there is enough open area where you can have a parking scheme going. But this is a complex and unusual thing. Thank you for joining me. If you have any questions, please let's deal with them in the discussion forum.